Ladies and gentlemen, hit subscribe right now. In a couple of seconds, you will hear Justice Clarence Thomas, the other justices, completely eviscerate the special counsel argument. Hit subscribe. Listen to this. He already essentially got immunity from the conservative Supreme Court justices. The special counsel essentially has already been given a devastating defeat. Hit subscribe. Listen to this. We'll get to the analysis after we hear about the amazing, after we hear the brilliant Justice Clarence Thomas completely dismantle the special counsel argument. Hit subscribe to my super chat. Thank you.
Mr. Dreeben, does the president have immunity, or are you saying that there's no immunity, presidential immunity, even for official acts?
Yes, Justice Thomas, but I think that it's important to put in perspective the position that we are offering the court today.
So the special counsel is saying even for official acts, there's no immunity. Okay, listen to this. This is completely absurd. So a speech is now not an official act, subject to criminal prosecution and imprisonment. Think about how ludicrous that is.
The president, as the head of the Article 2 branch, can assert as applied Article 2 objections to criminal laws that interfere with an exclusive power possessed by the president or that prevent the president from accomplishing his constitutionally assigned functions. That is the constitutional doctrine that currently governs the separation of powers. What petitioner is asking for is a broad blanket immunity that would protect the president, a former president, from any criminal exposure absent impeachment and conviction, which has never happened in our history. And we submit that is not necessary in order to assure that the president can perform all of the important tasks that the Constitution reposes in him.
Really quickly, why would it be impossible for the Senate to convict an obviously guilty president? Oh, because a special counsel and a Democratic Party administration is far more objective and apolitical and nonpartisan? Oh, is that the case? You would think that if Trump was this rampant criminal, that even Republicans would choose to convict him in the Senate. Oh, they're too partisan. So leave it to the nonpartisan, apolitical special counsel, the second one going after Trump, to then imprison him right before November of 24. Definitely about the rule of law. Definitely not about interference.
Over in not so distant past, the presidents or certain presidents have engaged in various activity, coups or operations like Operation Mongoose when I was a teenager, and yet there were no prosecutions.
Yes.
Why? If what you're saying is right, it would seem that that would have been ripe for criminal prosecution of someone.
So, Justice Thomas, I think this is a central question. The reason why there have not been prior criminal prosecutions is that there were not crimes. And I want to explain why there are layers of safeguards that assure that former presidents do not have to lightly assume criminal liability for any of their official acts. At the outset, there is a statutory construction principle that is applicable here. It arises when there is a serious constitutional question about applying a criminal statute to the president's acts. It is not, and I'm sure that we will discuss this, that no statute can apply to the president in his official capacity absent a designation of the president in it. But there is a principle that if there is a serious constitutional question, courts will strive to construe the statute so that it does not apply to the president. In addition to that, the president, I think has been mentioned earlier, has access to advice from the Attorney General, and it would be a due process problem to prosecute a president who received advice from the Attorney General
Why? Because William Barr was not on board with Trump, therefore Trump can be prosecuted. But if William Barr was on board, he couldn't be prosecuted. What kind of logic is that?
That his actions were lawful, absent the kind of collusion or conspiracy that itself represented a criminal violation, which I don't really see as being a realistic option.
So the special counsel just said the attorney general, if he advises the president that something is lawful, well, then you can't really indict. However, you could indict if the attorney general was in cahoots with the president and committing an unlawful act, which would mean that if the attorney general sided with Trump, then he too would be committing an unlawful act. Think about how absurd all of this is. The speech used the word peaceful. Not one person was influenced by Trump's speech. Not one person has been acquitted because they said, well, Trump made me do it. And the Federal Bureau of Investigation found no effort by Trump or any ally to try to foment a rebellion. So the Supreme Court, in a unanimous decision, overturned the Colorado ban. It'll be a 6-3, I think, decision. And yes, in a couple of weeks, we'll see. We'll get the official decision. I think it's already set in stone. So hit subscribe to this channel. Let's continue.
And then if I could say one more thing, because you raised the question about potential overseas taking of life. And the Office of Legal Counsel has addressed this quite specifically. There is a background principle of criminal law called the public authority exception to liability, and it is read into federal law unless Congress takes specific action to oust it, which it never has done as far as I am aware. And in a case in which the president sought to engage in overseas activity that would result in the taking of life, OLC did not say the federal murder statute doesn't apply. That would be the thrust of my friend's argument on clear statement. Instead, OLC went through an extensive analysis on why the public authority defense would prevent it from being considered a violation of law to go after a terrorist, for example.
So it is not a criminal offense by President Obama to overthrow a tyrant in Libya and then usher in a generation of chaos and a failed state. That would not be criminal for Bush or Obama or other Democrats and Republicans to commit, to engage in absolutely disastrous foreign policy, unlike Trump, who didn't get us into a military quagmire. So if the foreign policy decision of, let's say, President Obama in destabilizing Libya, if courts look at that in the U.S., they say, well, there's no way to indict a president for an immense loss of life because of his lack of wisdom or lack of foreign policy wisdom. But Trump, with a speech, this is the problem here. They're going after Trump because he performed a speech. Then you get this very naive rebuttal. Well, there are no official acts if the official acts are part of a criminal, Byzantine, all-encompassing, vague, broad criminal enterprise or plot. See, they're trying to get Trump on defrauding the U.S., the 18 U.S. Code 371, I believe. But they have to prove intent, which, of course, he never for 1 second believed that a person who couldn't form two sentences together actually defeated him. And his logic is he won Ohio and Florida, and that's only ever been done once, and the person lost. Every other time, the person has become president, in addition to other things that Trump found quite bizarre. Not one person was forced to testify under oath, like all the people around Trump who were forced to testify under oath during the Mueller probe, and yet they found nothing, and still people believe that he was a Kremlin operative. So the people who believe the most conspiratorial nonsense are the wonderful, morally superior liberal Democrats who still think that Trump is a Kremlin operative. despite the fact that he wasn't, and that the Mueller probe found no evidence, even though people were forced to testify under oath. That's the issue here. The issue is that he never got a legitimate investigation into his claims. They were very quick, vapid. Well, we spoke to a county level official and we're going to publish this, and false. And some of his claims were categorically false, Trump, but some of his claims were never investigated. I'm not going to go into which ones weren't investigated, but there were a number of issues that where Trump didn't have the luxury of a Mueller probe style investigation with endless congressional testimony and testimony in courts. Because if a county level official, let's say, or if a Democratic Party state level official, let's say, were forced to testify under oath, they might just possibly give a different answer under cross-examination than they give to an ally, another activist, or another liberal Democrat working for a major publication. So Trump absolutely believed that there was rampant criminality that took the contest 4 years ago away from him. So there goes your claim of defrauding the country. And he never got the opportunity to get anyone to testify under oath. He never had a legitimate investigation. He had journalists asking people at state level, either state level Democrats or county officials. They gave these journalists answers, and then suddenly it's gospel, the same, Bible that Democrats don't believe in, that Trump lied, everything was fine, there's nothing to see here. And of course, we're going to get him with, because what he did was he performed a speech. He spoke to Republicans in different states pertaining to what he felt was another DNC primary that railroaded Bernie Sanders. So in this case, he felt like he was Bernie Sanders. And so he had every right. In fact, it was his duty as president. It was an official act if he truly believed that there was rampant criminality, that Democrats engaged in rampant criminality, simply because quote unquote journalists or Democratic activists more appropriately, or the journalists in media by and large are actively supporting the Democratic Party. So if you get journalists asking county or state level officials to debunk Trump, it's a public relations machine aimed at only trying to dissuade people from believing anything Trump says. When in reality, most Republicans agree with Trump, and even some Democrats do, and most independents do. Because you look and you're like, well, how did somebody who can't even speak, who has obvious cognitive issues, who can't even utter a couple sentences together without, laboring and making up words and slurring in garbled speech. How could Trump lose to this caliber of person? Well, simply saying we spoke to this county official and they debunked Trump isn't enough. So there goes the defrauding the U.S., the 371 statute, the intent they'll never be able to prove in a million years. Okay? And because you never got an actual Mueller-style investigation. That's one of the reasons. But in addition to that, he's allowed to, an official act is a speech. An official act is speaking to his administration, speaking to Republicans in other states. Every president does that. Every president is allowed to speak to people in his political party in other states. You can't criminalize that. See, what they've done is they used very vague, broad, ambiguous statutes to say that his official acts were really unofficial. And then they make really absurd leaps of logic. Well, what if Trump tried to, take the life of his political opponent? Then he would have been impeached, genius. Then obviously the Republicans that stand by Trump won't be running on, oh yes, we kept Trump from going to prison even after everyone knows and the evidence shows he tried to eliminate political opponents. Even Republicans or Democrats can't run on that if a person in their political party actually tries to do that. But that's the absurd, outlandish leap of logic. They think that their indictments against Trump are just like if he was indicted for actually trying to take the life of a political opponent. But anyway, hit subscribe. Let's continue with this. This is really interesting. This is Chief Justice Roberts. It'll be 6-3. At least 6-3, possibly 5-4. It could be even 7-2. It really could be 7-2. You might even get one liberal justice.
The Court of Appeals below, whose decision we're reviewing, said, quote, a former president can be prosecuted for his official acts because the fact of the prosecution means that the former president has allegedly acted in defiance of the laws. Do you agree with that statement?
Why don't you own?
Well, I think it sounds tautologically true, but
so Chief Justice Roberts is saying, you think that he committed crimes and that his official acts were part of some kind of plot to commit a greater crime. Therefore, you're saying that he didn't commit official acts because his quote-unquote official acts were part of a personal criminal scheme. So therefore, a speech, therefore speaking to political allies, therefore speaking to administration officials, which of course are standard, the standard activity of any president. The special counsel says, well, those aren't official acts anymore. You know why? Because we've accused him of defrauding the U.S. So therefore, he doesn't have any right to presidential immunity. None of these justices are buying the nonsense. Of course he has a right to presidential immunity. You can accuse any president of performing a speech or speaking to political allies for personal gain. You could do that with any president.
But I want to underscore that the obligation of a president is to take care that the laws are faithfully executed.
Well, I think it sounds tautologically true as well, and that, I think, is the clearest statement of the court's holding, which is why it concerns me. As I read it, it says simply, a former president can be prosecuted because he's being prosecuted.
Well, I would not suggest that that's either the proper approach in this case or certainly not the government's approach.
So Justice Roberts completely eviscerated the logic. Oh, well, he's indicted. He's guilty because he's been indicted. That's not the way things work. You can't just accuse a president of criminal activity, even though nothing he did was outwardly criminal. They have to paint this narrative that each official act became unofficial and personal in nature and not protected by the Constitution because of some overriding plot, which, of course, didn't happen.
A prosecution does, of course, invoke federal criminal law. The allegations have to be presented to a grand jury, which votes upon the indictment.
Well, that's what I mean, shortly after that statement in the
And the special counsel working under a Democratic president says, well, we're not partisan. We're apolitical. We're not. We swore an oath to protect the Constitution. Well, so did every senator who voted to acquit Trump. So what's your point? Oh, because you would be nonpartisan and apolitical? So what he's saying is, well, you have to get a grand jury. But there have been people, innocent people, whose lives have been almost destroyed or destroyed by grand juries given wrong and biased information. In the Mueller probe, for example, there were grand juries, and yet Trump was completely innocent. And so were the people around Trump. They got them on process crimes, allegedly lying to bureau officials who were then themselves fired from the agency.
the court's opinion, that's what they said, but there's no reason to worry because the prosecutor will act in good faith, and there's no reason to worry because a grand jury will have returned the indictment. Now, you know how easy it is in many cases for a prosecutor to get a grand jury to bring an indictment, and reliance on the good faith of the prosecutor may not be enough in some cases. I'm not suggesting here. So if it's tautological, and those are the only protections that the Court of Appeals below gave, and that is no longer your position, you're not defending that position, why shouldn't we either send it back to the Court of Appeals or issue an opinion making clear that that's not the law?
Well, I am defending the Court of Appeals judgment, and I do think that there are layered safeguards that the court can take into account that will ameliorate concerns.
There aren't enough layered safeguards, and furthermore, it's irrelevant whether there are safeguards from political bias and animus. The point is, you're trying to create a precedent by imprisoning a president. Say that 1,000 times. You're creating a precedent by imprisoning a president because of a speech. Democrats want to create a precedent by imprisoning a president over a speech. Good luck trying to convince the conservative Supreme Court justices, and I think maybe it might even be 7-2. But it'll be 6-3 for sure, or 5-4, maybe Roberts. But Trump is going to get partial immunity at least. He won't get full immunity, he'll get partial immunity, and they'll bring it back to the lower courts to define what an official and unofficial act is, and then Trump's team will say, well, wrong. There are some official acts in the lower courts said were unofficial, and then he'll be president and completely dissolve the special counsel. And then hopefully, he creates a special counsel of his own. I think he deserves it after 2 were leveled against him. But they're trying to imprison a president over a speech, over speaking to political allies, over contesting results, which he had every single legitimate constitutional right to do. He went through the courts. He went through his lawyers. He went through 100% legal means. And they're trying to say that the chaos and mayhem were a direct result of his inability to accept results. That's not true. It's simply not true. Nobody who committed crimes that day were told by Trump to do anything. Again, the Federal Bureau of Investigation found no evidence of concerted effort by Trump or anyone else. That was right. If they wanted to indict and imprison Trump, they could have done so 2 years ago. They waited until November of 24, specifically to interfere. Do you think, ladies and gentlemen, that even the liberal justices don't realize there's politics at play? Of course there's politics at play. Of course there's politics at play. And again, Trump did not commit an actual crime. A speech is not an actual crime. Speaking to his administration officials is not an actual crime. They're trying to get him on a plot to subvert the will of the people through a speech and through legal means, which becomes illegal if indeed he was trying to subvert the will of the people. Because he knew he was wrong. He knew all the good journalists who spoke to county level and state level officials and debunked Trump. He was debunked. He knew that he was wrong from the beginning and that, the sleepy one, the mashed potato brains, actually defeated him. But of course, there's not a shred in Trump's body. There's not, I should say, an atom in his body that actually believes that he lost in a legitimate manner. Just like Democrats still believe that Trump cheated them. That's what the hush money trial is about. They're still litigating Clinton's loss. And I can't see. I still think Clinton somehow they'll switch horses midstream. I just think that Clinton has to replace mashed potato brains. I just don't see. I think that she's just waiting. That's the only chance they possibly have, because Trump is going to win, hopefully in a landslide.
About unduly chilling presidential conduct. That concerns us.
It was not unduly chilling.
We are not endorsing a regime that we think would expose former presidents to criminal prosecution in bad faith, for political animus, without adequate evidence. A politically driven prosecution would violate the Constitution under Waite versus United States.
We would never violate the Constitution in order to imprison Trump for 700 years. We would never do that.
It's not something within the arsenal of prosecutors to do. Prosecutors take an oath, the Attorney General takes an oath. So, I don't want to overstate Your Honor's concern.
The good and very honorable prosecutors in New York are doing so for the rule of law. Definitely not in any way, shape, or form for the Democratic Party.
With potentially relying solely on good faith. But that's an ingredient, and then the courts stand ready to adjudicate motions based on selective prosecution, political animus. This court relied on those very protections in the Vance case just 2 years ago.
But what concerns me is, as you know, the Court of Appeals did not get into a focused consideration of what acts we're talking about or what documents we're talking about because of its adoption of what you termed, and I agree quite correctly, as a tautological statement, because the fact of prosecution was enough to take away any official immunity. The fact of prosecution.
The mere fact they accused Trump of crimes suddenly means he's not protected at all, even though he was president with the Constitution protecting the executive branch or the commander-in-chief. How absurd is that?
They had no need to look at what
Mark Zuckerberg just
courts normally look at when you're talking about a privilege or immunity question.
Well, I think I would take issue, Mr. Chief Justice, with the idea of taking away immunity. There is no immunity that is in the Constitution unless this court creates it today. There certainly is no textual immunity. We do not submit that that's the end of the story. United States versus Nixon wasn't a textually based case. Neither was Nixon versus Fitzgerald. We endorse.
Suddenly, the liberal Democrat is an originalist and a text focusing on what the text states.
Both of those holdings. But what is important is that no public official has ever had the kind of absolute criminal immunity that my friend speaks of, even with respect to the speech or debate clause. It's very narrow. It's focused on legislative acts. It's not focused on everything that a congressman does. And it responds to a very specific historical circumstance that basically involved the two other branches potentially harassing legislators and preventing them from doing their jobs. That's why it ended up in the Constitution. Nothing like that ended up in the Constitution for the presidents, and that's because one of the chief concerns of the framers was the risk of presidential misconduct.
Every time the special counsel or the Colorado Supreme Court lawyer or the DOJ lawyer the other day talking about what the framers wanted, every single time a lawyer, wonderful liberal Democratic Party leaning lawyer, gives these justices a history lesson, the justices then completely ignore it and actually side with Trump. When you're giving these justices, all 9 of them are brilliant. They don't need a history lesson on anything. They already know U.S. history better than almost anyone in the country. So when you're giving a history lesson, then you're actually conceding that you don't really have any logical rebuttal, or you can't really explain why you want to imprison Trump. So you just say, well, the founders, they really they wanted to imprison Trump.
labored over this. They adopted an impeachment structure that separated removal from office as a political remedy from criminal prosecution. This departed from the British model. The British model was you get impeached and criminally prosecuted and convicted in the same proceeding. The framers did not want that. They wanted a political remedy in case a president was engaging in conduct that endangered the nation. He could be removed. He can't be prosecuted while he's a sitting president.
What on earth did Trump do to endanger the nation? The only entity that felt threatened by Trump was the Democratic Party. And even then, I don't remember even one Democrat or pundit, liberal pundit, actually saying Trump could actually remain in office. Not one of them believed. In fact, they were jumping for joy in the streets when Trump lost every single case because the judges wanted absolute evidence that second for his claims, and there needed to be actual investigations with people testifying under oath, which he was never going to get. So, if he didn't have William Barr's, if he didn't have the Justice Department or the Federal Bureau of Investigation or everything, all the agencies that fully back the absurd allegations that Trump was a Kremlin operative, if he didn't get that, if he didn't have the luxury or the benefit of having those agencies backing him, he wasn't going to be able to do anything in terms of the courts. He was going to lose those court cases, which he did. But he didn't endanger the country. Okay? Even with the chaos and mayhem of that day, they still ushered in an era of Biden's presidency. So how did the country, what did this man do other than contest results through legal means? And the fact that he contested results through legal means, he's accused of not doing so because he did so. Isn't that bizarre? He contested results through the courts, through his lawyers, through political allies, and they said because he did so, he's a criminal. Okay. Oh, he pressured people. He pressured. How do you prove anyone was pressured? Nobody did what he was asking. He's terrible at pressuring people. There's not one person who actually followed his lead. William Barr didn't. The people in red states didn't. The Republicans in red states didn't. So what does this man do? Oh, it's phony. He tried to deceive with Pence. There's already precedent in U.S. history for alternates. And the alternates existed only because the precedent said during court cases, you can have an alternate set of you-know-what. And just, the algorithm. So, anyway, let's continue.
President, that's been the longstanding Justice Department position.
Mr. Dreeben, you dispute the proposition that a former president has some form of immunity. But as I understand your argument, you do recognize that a former president has a form of special protection, namely that statutes that are applicable to everybody must be interpreted differently under some circumstances when they are applied to a former president. Isn't that true?
It is true because Justice Alito of the general principle that courts construe statutes to avoid serious constitutional questions, and that has been the longstanding practice of the Office of Legal Counsel in the Department of Justice.
All right, so
Wow.
This is more, I think, than just a quarrel about terminology, whether what the former president gets is some form of immunity or some form of special protection, because it involves this difference, which I'm sure you're very well aware of. If it's just a form of special protection, in other words, statutes will be interpreted differently as applied to a former president, then that is something that has to be litigated at trial. The former president can make a motion to dismiss and may cite OLC opinions, and the district court may say, well, that's fine, I'm not bound by OLC, and I interpret it differently, so let's go to trial. And then there has to be a trial, and that may involve great expense, and it may take up a lot of time. And during the trial, the former president may be unable to engage in other activities that the former president would want to engage in. And then the outcome is dependent on the jury, the instructions to the jury, and how the jury returns a verdict, and then it has to be taken up on appeal. So the protection is greatly diluted if you take the form, if it takes the form that you have proposed. Now, why is that better?
It's better because it's more balanced.
It's better because it's more balanced? What? It's more balanced that you're trying to literally imprison Trump, not fine him, imprison him. They want him to end his life in a prison cell because of a speech that literally had nothing to do with the chaos and mayhem of that day. They say that it did. It had nothing to do with it. He used the word peaceful. None of the defendants in January are saying, none of the defendants have a defense that says Trump made them do it. And so you could read the indictment for yourself. It's broad, ambiguous, and you could do that with any president. You could say, you know, that president was flying to this state and performed a speech, and at the same time he was speaking to political allies, and it was this grandiose plot to deceive the country, when in reality he should have been doing this, or that, or something else. Oh, and chaos ensued after his speech in a completely different location. Therefore, we're going to imprison this president. Okay? How many people were influenced by the words of Democrats after the Dobbs decision 4 years ago during that summer with billions in property damage? And Democrats, Democratic Party organizations or organizations linked to the Democrats bailed out protest demonstrators. 14,000 people were arrested. And it's like, you know, that was a terrible day in January. Trump shouldn't have had that day. But the chaos and mayhem had literally nothing to do with him. He didn't. Does anyone on the planet, even people wanting to imprison Trump, even Democrats who want to imprison, do you think that, is there a Democrat that actually believes Trump wanted that mayhem and chaos? How would it benefit him? There was no way to prevent Biden from winning. Trump knew that. This was him trying to demonstrate, just like Democrats or liberal or progressive demonstrated that summer. But again, God bless Trump. Awesome, man. Wonderful. Very stands on integrity, unlike Democrats who have zero foreign policy vision. He has foreign policy vision. First president to step foot in North Korea. Moved the embassy to Jerusalem. Doha Agreement brought Americans home. Abraham Accords. The Doha Agreement, that was a May 1st, 2021 withdrawal. That's why Biden, one of the reasons he's so terrible, it was a May 1st withdrawal. He didn't even abide by the agreement of his predecessor. And then those Americans should be alive today. Those Afghans should be alive today. That was 100% the current president's fault. Can you impeach him for that? Why not? Or can you imprison him for that? Well, I guess not. Well, you know what? Who knows? This special counsel says, you can't really impeach him for foreign policy. But you know what? If it's a May 1st, 2021 withdrawal, the Doha Agreement states, and you deliberately ignore that withdrawal date, why don't you imprison this current president after he leaves office? Why not? And you actually have, well, you had lives lost, but those were supporters of Trump. An unarmed woman, her life was taken that day. But you have a loss of American lives because of the chaos that was allowed to unfold, linked directly to Biden's decision-making. But anyway, let's continue.
A blanket immunity that petitioner is arguing for just means that criminal prosecution is off the table unless he says that impeachment and conviction have occurred. Those are political remedies that are extremely difficult to achieve in a case where the misconduct occurs close to the end of a president's term. Congress is unlikely to crank up the machinery to do it. And if the impeachment trial has to occur after the president has left office, there's an open question about whether that can happen at all. So
you're arguing against the most far-reaching aspects of.
The special counsel doesn't want to even open up the possibility that impeachment is a remedy and conviction in the Senate is a remedy because of the belief that Republicans in the Senate or Democrats in the Senate would never, well, Democrats wouldn't, Republicans probably would, this Republican Party, but if a president, Democrat or Republican, literally ordered the elimination of a political rival, and there was enough evidence that the entire world could see it, the Democrats and Republicans can't run on, oh, we protected this man from prison, even though everyone knows what he did. So if it's so apparent, why doesn't the special counsel even address the issue of impeachment and Trump's acquittal? Because they're trying to tell the world that they are nonpartisan, a special counsel for Biden's administration going after Trump months before November, apolitical, definitely not interfering in 24, and doing it for the rule of law. Whereas Trump was acquitted, and that wasn't about the rule of law. Even though his crimes were so obvious to the world, he was still acquitted and not convicted in the Senate. Why is that? Because he didn't commit any crimes. He didn't commit any crimes. Had he committed crimes, he would have been convicted. Nobody even knew what the special counsel was going to indict Trump on until they eventually indicted Trump.
Of Mr. Sauer's argument, right?
That is correct. And let me turn then to why.
Well, what about, to unpack it a little more, do you agree that there's some aspects of Article 2 presidential power that are exclusive and that Congress cannot regulate and therefore cannot criminalize?
Absolutely.
Okay. For other official acts that the president may take that are not within that exclusive power, assume for the sake of argument, this question, that there's not blanket immunity for those official acts, but that to preserve the separation of powers, to provide fair notice, to make sure Congress has thought about this, that Congress has to speak clearly to criminalize official acts of the president by a specific reference. That seems to be what the OLC opinions suggest. I know you have a little bit of a disagreement with that, and what this court's cases also suggest.
So, Justice Kavanaugh, I'd like to take all of those in turn because I don't think this court's cases speak that broadly. I definitely don't think that the Office of Legal Counsel opinions stand for this broad proposition that unless the president is specifically named, he's not in the statute. And I don't think that that's necessary in order to afford adequate protection for the president's valid Article 2 functions.
When you said unless, sorry to interrupt, but I want to just get this out and you can incorporate it in the answer. You said unless there's a serious constitutional question.
Right.
Well, it's a serious constitutional question whether a statute can be applied to the president's official acts. So wouldn't you always interpret the statute not to apply to the president, even under your formulation, unless Congress had spoken with some clarity?
I don't think across the board that a serious constitutional question exists on applying any criminal statute to the president.
The problem is the vague obstruction and 371, conspiracy to defraud the United States, can be used against a lot of presidential activities historically.
Exactly, and that's why the special counsel used those statutes. There's no statute that says a speech is criminal. There's no statute that says speaking to your lawyer is criminal. You have attorney-client privilege. There's no statute that says speaking to political allies is criminal. Trump did all of those things. But the vague, broad, ambiguous statutes of defrauding the U.S., they leveled at Trump. Because they said, well, he knew he was wrong and he was trying to deceive the country. Still, most Republicans and most independents and a number of Democrats still believe. You look at the man running our country now and you say, I hope he's okay. God bless him. And not only are there cognitive issues, but there's like everyone sees what's going on. It's like embarrassing to even talk about. So how did Trump lose is the question. He lost. But no, but see, Democrats, when they do this with every issue that they find could hurt them politically. They turn it into this. They revere their version of the truth or their version of reality. The truth oftentimes doesn't correlate to the Democratic Party narrative. You could ask Bernie Sanders. Actually, don't ask me anything, because I won't help Putin. Rootin' tootin' if you're listening. I don't want your help. That's literally what the man yelled out one time. I mean, you're talking about the anti-Trump is Bernie Sanders. They could do anything to him, and Bernie will say, "Thank you, may I have another?" But with Trump, he actually stands up for himself, and that's a big no-no with Democrats.
With a creative prosecutor who wants to go after a president.
Well, let me try to backtrack a little bit.
That's what we're talking about historically, is the risk.
Let's listen to this again.
And going forward.
Proposition that unless the president is specifically named, he's not in the statute. And I don't think that that's necessary in order to afford adequate protection for the president's valid Article 2 functions.
When you said unless, sorry to interrupt, but I want to just get this out and you can incorporate it in the answer. You said unless there's a serious constitutional question.
Correct.
Well, it's a serious constitutional question whether a statute can be applied to the president's official acts. So wouldn't you always interpret the statute not to apply to the president, even under your formulation, unless Congress had spoken with some clarity?
I don't think across the board that a serious constitutional question exists on applying any criminal statute to the president.
The problem is the vague obstruction and 371, conspiracy to defraud the United States, can be used against a lot of.
When I was accepted to SGU, that was one of the great
presidential activities historically with a creative prosecutor who wants to go after a president.
Well, let me try to backtrack a little bit.
That's what we're talking about historically, is the risk and going forward, the risk. So you can take all of that.
I think that the question about the risk is very serious, and obviously it is a question that this court has to evaluate. For the executive branch, our view is that there is a balanced protection that better serves the interest of the Constitution, that incorporates both accountability and protection for the president. And
a balanced protection that allows us to both imprison Trump and protect future Democrats from the same type of imprisonment.
I want to go through the protections that do exist, but perhaps it's worth returning at the outset to the statutory construction question that you raised. The Office of Legal Counsel has said the offense of bribery, of course, applies to the president. It does not name the president. Justice Gorsuch, Section 201 does not specifically name the president.
I would assume that's personal, so.
Well, I think that
that's what Brewster said.
Bribery statute in 607 says the president. I've got it in front of me, and so there is that.
Well,
let me just back up, though, just a second to what was a quick exchange with Justice Kavanaugh that I just want to make sure I understand.
Yep.
Did you agree that there are some core functions of the executive that President conduct that Congress cannot criminalize?
Yes.
So is that a form? I mean, we can call it immunity, or you can call it they can't do it, but what's the difference?
We call it an as-applied Article 2 challenge.
We don't call it immunity. We call it Article 2 challenge. Imprison Trump forever statute.
Can we call it immunity just for shorthand's sake? So I think we are kind of narrowing the ground of dispute here. It seems to me there is some area.
There is is immunity, but we don't call it immunity because Trump could possibly be imprisoned and we want him to be imprisoned. So we call it not really immunity, maybe immunity light, definitely not for Trump, but for future Democrats.
You concede that an official acts that Congress cannot criminalize, and now we're just talking about the scope.
Well, I don't think it's a just, but I think it's a very significant gap between any official act and the small core of exclusive official acts.
I got that, but I want to explore that, okay? So, for example, let's say a president leads a mostly peaceful protest sit-in in front of Congress because he objects to a piece of legislation that's going through. And it, in fact, delays the proceedings in Congress. Now, under 1512C2, that might be corruptly impeding an official proceeding. Is that core and therefore immunized, or whatever word euphemism you want to use for that? Or is that not core and therefore prosecutable?
Well,
without a clear statement that applies to the president.
It's not core. The core kinds of activities that the court has acknowledged are the things that I would run through the Youngstown analysis. And it's a pretty small set, but things like the pardon power, the power to recognize foreign nations, the power to veto legislation, the power to make appointments, these are things that
Why would the special counsel concede to any of these official acts if, under 371, the statute they used, even official acts aren't protected if the president engaged in some broad, grandiose plot? So the special counsel is not even answering the question. Or I should say, the special counsel, the indictment against Trump is an indictment that imprisons him for official acts. Because these official acts became unofficial once he engaged in a criminal scheme. So what if there was a criminal scheme to do all the other official acts that now the special counsel says is protected?
The Constitution specifically allocates to the president. Once you get out...
A president then could be prosecuted for the conduct I described after he leaves office?
Probably not, but I want to explain the framework of why I don't think that would be prosecution that would be valid. First, I think you need to run through all of the sort of normal categories of analysis. Is there a serious constitutional question that's posed by applying that statute to the president? If so, then you may well default to it does not apply, at least on that fact
well, I thought you said it, that was my question.
Yes,
and
I
you said it fell outside that core, we'll call it immunity for simplicity's sake.
Yes, I understand. But there's a separate category.
Okay, so why couldn't he be prosecuted for leading a civil rights protest in front of the Capitol that delays a vote on a piece of important legislation?
So I think what you need to do is run through all of the very president-specific protective layers of analysis. So one of them is whether the statute would be construed not to apply to his conduct, even if it's not part of that small core of things that Congress can't regulate at all. If it operates to prevent the president from fulfilling his Article 2.
He could have given speeches against it. He did.
Yes.
But he did something more, and it corruptly impeded and sought to influence an official proceeding.
Well, so I don't know. We're starting with the layers, I think, of protection, and we're now down through whether the statute would be construed to apply to him. Then there'd be a question of whether...
Assume it does.
The special counsel's like, why are you doing this to me? We're just trying to imprison Trump. This is our natural right.
I will assume it. Then there's a question of whether he has the state of mind necessarily to violate
he does. Okay. Nobody knows what corrupt intent means. We've been around that tree
we will probably find out.
And maybe it means that he knows that he was doing wrong, is what the government told us.
Right.
He knows he's doing wrong. He knows he shouldn't be up there blocking a congressman from going.
Well, let me get to the next layer then, which is that the president does have access to the attorney general to provide legal advice and regularly.
The next layer If the next layer was William Barr defending Trump, they would then have indicted William Barr.
He gets legal advice from the Attorney General on the lawful scope of the president's activities. And we could go down two tracks here. One is that the Attorney General advises him that as an incident of his Article II authority and in carrying out the functions of the presidency, he can lawfully participate in that.
Did you work in the nuclear weapons or uranium industries?
First Amendment analog to the president's official powers, which the court is exploring in other cases. Alternatively, the Attorney General could advise him, I'm sorry, Mr. President, there's nothing in the language of this statute that carves you out. I don't see a serious constitutional question in it because you don't have to do that. And I would advise you not to violate the criminal law.
And then he could be prosecuted.
No.
No. If he gets a negative opinion from the Attorney General, he still couldn't be prosecuted?
I'm going to assume that most presidents are not going to take
but if he gets one and does it anyway, then he could be prosecuted.
Well, so then if we are down at that level, I think what we are really asking is whether the president is subject to the criminal law. And our answer is yes, he is subject to the criminal law.
Mr. Dreeben, can we go back to the bribery statute?
Lou, thank you. Lou Maldonado, thank you so very much to my super chat. I think it's going to be 6-3. Could be 5-4, could be 7-2. But I think 6-3. I think it'll be 6-3. Supreme Court siding with Trump over partial immunity. Partial immunity. At least partial immunity. Not full immunity, but partial immunity. And again, he's not going to be the only case where Trump will be convicted, maybe, is the hush money case. And even that will be overturned, but it would take 2 years to be overturned. So, and Democrats every day, convicted felon Trump. Anyway, hit subscribe. Lou, thank you. If you're new to the channel, hit subscribe. Be here through November and beyond. God bless you all, everybody. Thank you so very, very much. I'll see you tomorrow, everyone. This is going to be a huge victory.